Defendant's motion to dismiss count 2 is granted in part and denied in part. Count 2 is dismissed without prejudice. Plaintiff's motion to remand count 2 is denied. That is a ruling from a federal judge in the Southern District of Illinois in the Myers v. Kelly case, challenging Illinois' firearm owner ID card law, but also challenging the state's law that limits where people can sue the states on constitutional grounds to just 2 of 102 counties in the state of Illinois. Welcome back. It's Bishop on Air. I'm Greg Bishop. Thanks for hanging out. Like, subscribe, hit that notification bell, and join us each and every weekday morning as we go through stuff that's impacting you here right in Illinois. All right, so we've been tracking, of course, a lot of the litigation against the state's gun and magazine ban, and that is something enacted back in January of 2023. Lawsuits filed shortly thereafter in state court and federal court. Some cases were transferred to federal court. In the Southern District of Illinois, you had consolidation of several challenges, and then that went up to the appeals court, and now you've got the U.S. Supreme Court being asked to intervene. While back at the Southern District, they're dealing with the merits. So all of that's still playing out. But if you recall, if you've been following along with us for as long as we've been covering these things here with Bishop on Air, you know about the Myers v. Kelly case. And Myers v. Kelly deals with the FOID card. And let's just look at the docket here from the federal court. So you've got the U.S. District Court in the Southern District of Illinois. Back in July of 23, so July 24th of 2023, you have the case being moved from Madison County State Court to federal court. So what this case deals with is an individual denied a firearm owner ID card, and for whatever reasons, they challenged that, but they filed their case in Madison County and also challenged, it was a 2-count challenge, not just the FOID card. That's count 1. Count 2 is the challenge of the state's venue limit law, which there are other challenges and other courts dealing with that. And even you've got the case in state court all the way up to the Illinois Supreme Court challenging the venue limiting law. And that deals with, a case concerning, firearm legislation. So clearly this is an ongoing issue that is being dealt with by the federal courts. But if you look at the docket, if you go all the way down, excuse me, I got a frog in my throat. If you go all the way down, you'll see that the Myers v. Kelly case, you had the judge essentially set up, the ongoing orders to have discovery. Looking at, for instance, back in October, schedule of the discovery was May 31st of this year. So we're getting ready to see that happen. But then you had late last month, an order being granted by the judge. Looking at count 1, they're keeping that, but count 2, they're dismissing that without prejudice. So let's go into this in some detail as we look at this together here. Again, with Bishop on Air, and be sure to like, subscribe, and hit that notification bell. All right, so all the way here we got the memorandum and order that the judge offered up in this case, where you had the state's motion to dismiss count 2. Plaintiffs didn't respond to that motion to dismiss count 2. Instead, plaintiffs filed a motion to remand count 2 back to state courts. But the judge, as he explains in this 13-page order, grants in part and denies in part the motion to dismiss count 2, the venue limiting law. Count 2 is dismissed without prejudice. Now note, this does not touch count 1, the challenge to the FOID card. So you go through and you read a lot of the legalese and you look at what's being argued here, and the state essentially saying, hey, there's been no injury to this individual, who the individual claims to have been a person of lesser means, and having to travel to either Sangamon County or Cook County, quote, would impose a substantial difficulty for plaintiff to vindicate his rights. Also going on to say that he's not well off, is relatively poor, and suffers from a severe and substantial physical medical condition that limits his ability to travel long distances. So that was the argument in count 2, saying that the state's law limiting only lawsuits going into Sangamon County or Cook County would harm his ability to defend himself or to vindicate his rights, as they say. So you go through and you read the analysis, and the state saying that the case should be dismissed. Instead of replying to that motion to dismiss, the plaintiffs, those who are suing the state, simply put in a different motion. Tactfully, using this tactic, they just put in a motion to have it remanded back to the Madison County Court. So the legal precedents, all the citing of previous cases and looking at court rules and such, the judge goes back and forth between these various arguments. But here's just some I'll read to you. And what the judge ultimately found here. It's also noteworthy that while subject matter jurisdiction and, by extension, standing cannot be waived, plaintiff presents no responsive argument whatsoever on the pressing issue, and that's about standing. Does this individual have proof that they're currently being harmed? Not just supposing that they could be harmed, but do they have proof that they're actually being harmed? And the plaintiffs present no responsive argument whatsoever in this pressing issue. As stated above, plaintiff merely tepidly asserts if defendant is correct about this court's jurisdiction over count 2, it's back to state court we must go. In any event, the court now agrees that plaintiffs presently lack standing to assert count 2. Defendant has taken no action, and this is what's important here. The state took no action in state court before this case was transferred to the federal court. The state, as defendants, took no action in state court trying to move the case from Madison County to Sangamon County. As such, plaintiffs have not suffered an injury, the judge says. A transfer of venue from Circuit Court of Madison County to Circuit Court of Cook or Sangamon County. By extension, plaintiffs have not suffered the harm of which he complains, namely a constitutional violation or the financial and physical burden of traveling to Cook or Sangamon County. So it hasn't happened yet, essentially, is what the judge is saying. And that's what the state is saying. They're saying that there is no injury that the plaintiffs can allege because the state has not moved forward with that. So it goes on to highlight various other cases, and it says, by virtue of these conclusions, the court need not address the alleged mootness of count 2. Also, the court stresses that it has not, and indeed it could not, opine on the constitutionality of the count in the absence of subject matter jurisdiction. Likewise, the court takes no position on whether, on a different record, standing could be established to challenge the law. So what we have here ultimately is a judge deciding that, count 1 is still moving forward. So May 31st, discovery is going to have to start happening. And this, again, is challenging the firearm owner ID card law in state court. And I'm not an attorney, but just reading this and presenting it for you so you can try to, follow along with me. I mean, it's always interesting how litigation evolves and progresses, right? I mean, this started in state court with 2 counts, was transferred to federal court, and now they're looking at dismissing the second count. So the first count stays in federal court, but the second count is not being remanded back to state court. It's just simply being dismissed. And Nakuda says, blah, blah, blah. A lot of legal words all in throughout these documents, and hopefully just giving you a little bit of an overview here helps you better understand where these cases go, how they can evolve, and where we're headed to next. Again, they do have discovery due by May 31st. 2024. So we'll see how that plays out. Dispositive motions are due by June 30th of 2024. So this case is seemingly moving forward, at least on the FOID card issue, not on the court jurisdiction question, which there are other cases, even in state court, all the way up in the Illinois Supreme Court, I believe, that are having to deal with these questions. So we'll be watching all of that. It is Bishop on Air. I'm Greg Bishop. Thanks for hanging out on this Friday. And be sure to like, subscribe, and hit that notification bell, all right? Make it happen, folks.